NASCAR, y'all should have just paid Michael Jordan's legal fees if that's all it was going to take to settle this thing.
Michael Jordan and Denny Hamlin just found themselves facing the fallout of major revelations in their federal antitrust lawsuit against NASCAR. The new details emerging from the case threaten to expose deep problems inside the sport and could trigger changes NASCAR has long tried to avoid. This legal drama has been brewing since 2024, when 23XI Racing and Front Row Motorsports jointly filed suit against NASCAR over the contentious charter agreement. At its core, the lawsuit alleges that NASCAR has exercised monopolistic control over the premier stock car racing market, with trial proceedings set to begin in Charlotte, North Carolina on December 1st, 2025. The world is watching closely. The trial will run for 10 days and is expected to bring major American sports and motorsport figures into the courtroom. U.S. District Judge Kenneth Bell will preside over the proceedings, and both sides have enlisted top-tier legal firepower. Representing 23XI and Front Row is Jeffrey Kessler, a legal titan who scored a landmark 9-0 victory in NCAA versus Alston. NASCAR, meanwhile, has hired Christopher Yates of Latham & Watkins, a heavyweight in antitrust defense. The legal and cultural stakes are enormous. NASCAR isn't just fighting to protect its business practices, it's battling to maintain control over the most valuable commodity in motorsports: access. Charters, which are essentially contracts that guarantee entry into NASCAR-sanctioned races, are at the heart of this dispute. The contracts come with restrictive clauses, including non-compete agreements and mutual releases of claims that teams, like 23XI argue, are designed to squash competition. Michael Jordan has emerged as the lead representative for 23XI Racing during the trial, a move that many see as strategic. As North Carolina native and a Tar Heels legend, Jordan's presence in the courtroom is expected to sway jurors. Journalist Jeff Gluck speculated that attorney Jeffrey Kessler specifically wanted the jury to see Jordan every day in court, not just for the optics, but to emphasize the seriousness of 23XI's claims. Court documents reveal that Jordan is not just lending his name to the cause, he's putting serious money on the line. In 2025, Jordan paid 60% of the $28 million it cost to purchase a charter from the now-defunct Stewart-Haas Racing. He also shared the cost of 23XI's new racing headquarters with Hamlin and has been fronting the team's legal expenses. Contrary to previous speculation that Jordan was merely a figurehead, it's now clear he has substantial financial and emotional investment in 23XI's future. According to reporter Bob Pockras, Jordan even loaned Hamlin his share of the recent charter purchase, which Hamlin is repaying in monthly installments. This revelation effectively shuts down the long-standing rumor that Jordan has no skin in the game. Veteran spotter Brett Griffin summed it up on X, formerly Twitter. The rumor MJ has no skin in the game and only using his name is dead. The messages I've seen about owners, drivers, and fans are "fuck you, disgusting, I'm a redneck and I'm proud of it." The lawsuit has already unearthed explosive information. Pre-trial depositions have painted NASCAR executives in a highly unflattering light. One of the most damning pieces of evidence is a series of derogatory text messages exchanged in 2023 between NASCAR Commissioner Steve Phelps and Vice President Brian Herbst. In the messages, Phelps referred to Hall of Fame team owner Richard Childress as an idiot and a redneck. He went even further by saying Childress owes his entire fortune to NASCAR. Childress's team has reportedly considered legal action over the comments. The backlash has only intensified, with fans and stakeholders questioning the culture within NASCAR's leadership. Adding to the drama, another set of messages reveals NASCAR President Steve O'Donnell attacking Hamlin for participating in Tony Stewart's rival SRX series. O'Donnell's text to Phelps included, "This is NASCAR, pure and simple. Enough. We need legal to take a shot at this." And "These guys are just plain stupid. Need to put a knife in this trash series." This deepening internal controversy has severely undermined NASCAR's public image, making it harder for the association to defend its practices as being in the best interest of the sport. One of NASCAR's primary arguments is that it achieved its dominant position through merit and sound decision-making, not coercion. NASCAR points to the skyrocketing value of charters, some reaching $45 million, as proof that teams are thriving under the current system. They highlight examples like Team Penske and Rick Hendrick's cross-participation in IndyCar to demonstrate that teams aren't being boxed into exclusivity. But 2311 and Front Row paint a different picture. They argue the charter agreements are structured to prevent teams from exploring alternative ventures or series. According to their claim, this creates a monopsony, where NASCAR is the only viable buyer of racing team services, limiting team earnings and stifling innovation. They further assert that NASCAR's control extends to non-compete clauses and track ownership restrictions, which make it virtually impossible for rival leagues to gain traction. 2311's legal team will rely heavily on economic data and expert testimony to argue that this environment suppresses competition and violates antitrust laws. The contrast between NASCAR's narrative and 2311's couldn't be starker. NASCAR wants to position itself as a merit-based organization that encourages growth. 2311 and Front Row argue that the current system is an outdated, restrictive regime that benefits a few entrenched interests at the expense of newcomers. It's not just owners who may testify. Drivers like Bubba Wallace and Tyler Reddick could be called to speak about how the charter system has impacted their careers and opportunities. This personal angle could be pivotal in swaying jurors. One revealing point emerged during court filings. NASCAR's 3 preliminary injunctions and multiple mediation attempts before trial underscore the high-stakes nature of this case. Judge Kenneth Bell also ruled that NASCAR enjoys monopolistic power specifically in the premier stock car racing market, not diluted by other series like F1 or IndyCar. This definition strengthens the plaintiff's argument and narrows NASCAR's scope of defense. The courtroom battle is expected to be complex and technical. Antitrust law is notoriously difficult to litigate. Lawyers must distill complicated economic models and hypothetical market behaviors into digestible arguments for a lay jury. A similar case against the NFL was overturned last year due to juror confusion, highlighting the importance of clarity. However, one element that will need no translation is Michael Jordan's testimony. As one of the most recognizable figures in the world, Jordan's involvement brings a cultural weight to the case that no amount of legal precedent can counterbalance. Whether he helps 2311 win or falters under cross-examination, his presence ensures this case will be watched far beyond NASCAR's usual circles. Even if the trial concludes in 10 days, the legal war is far from over. Appeals are almost guaranteed. The losing side will likely take the case to the U.S. Court of Appeals for the Fourth Circuit and potentially even to the Supreme Court. This case, like so many others in modern sports law, could drag on for years. Regardless of the outcome, the trial will reshape NASCAR's future. If 2311 and Front Row prevail, expect calls for more equitable charter distribution and possibly even a structural overhaul. If NASCAR wins, the current model will be cemented, but at the cost of exposing internal rifts and alienating stakeholders. In the end, what's unfolding in Charlotte isn't just a courtroom drama, it's a power struggle over the soul of American motorsport. And with Michael Jordan front and center, every lap of this legal race is guaranteed to make headlines.